Good evening, everyone. Thank you for joining us this evening for the 2022 Sir Francis Burt Oration. My name is Alain Musicat. I'm the chairman of the Francis Burt Chambers Board. I'll begin by acknowledging the traditional custodians of the lands upon which we meet, the Wajaka people of the Noongar Nation, and I pay my respects to the elders past, present and emerging, and acknowledge their continuing stewardship of these lands. I also extend a warm welcome to our distinguished guests here tonight. I will not identify them all by name, but in addition to the many members of the profession here this evening, I acknowledge the presence of the Honourable Chief Justice of Western Australia, Mr. Joseph Quinlan, judges and registrars of many courts and tribunals, including the Court of Appeal, General Division of the Supreme Court of Western Australia, Federal Court of Australia, Family Court of Western Australia, State Administrative Tribunal, including President, the Honourable Justice Janine Pritchard, and both Deputy Presidents, the District Court of Western Australia, including Her Honour Chief Judge Judy Wager, the Magistrates Court of Western Australia. I also extend a warm welcome to the Solicitor General, Joshua Thompson SC, President of the WA Bar Association, Mr. Brahma Dominand SC, and the President of the Law Society of Western Australia, Ms. Rebecca Lee. It is also my very special pleasure to be able to welcome Sally O'Connor, daughter of the late Sir Francis Burt, and her husband Tina. Sir Francis was, of course, both a trailblazer within the WA legal profession and a giant of the law of the state. He was admitted to practice in 1941, took silk in 1959, and became president of the WA Law Society the following year. In early 1961, Sir Francis took the bold step of retiring from the law firm at which he was senior partner to commence practice solely as a barrister. In doing so, he became the founder of the independent bar in Western Australia. Sir Francis was soon joined by others, and 60 years ago, in 1962, it was announced that separate barristers' chambers had been constituted at 81 St George's Terrace in Perth. These were WA's first barristers' chambers. Together, Sir Francis and his fellow founding members adopted the simple name Bar Chambers to describe them. Some 35 years later, Bar Chambers was renamed Sir Francis Burt Chambers in honour of Sir Francis' enduring legacy. Sir Francis was appointed to the Supreme Court of Western Australia in 1969 and served as our 11th Chief Justice from 1977 until 1988. He was later appointed Governor of Western Australia, a position he occupied for over 3 years. Since 2019, our Chambers has hosted the Sir Francis Burt Oration on an annual basis. The Oration seeks to honour the legacy of the late Sir Francis by asking speakers to share their considered thoughts on present and emerging matters of interest and importance to the legal profession, particularly where the law and the profession intersect with broader society. 2022 marks the 60th anniversary of the establishment of our chambers, which also bears Sir Francis's name. And this evening we are delighted to have the current Chief Justice of Western Australia, the Honourable Justice Peter Quinlan, as our guest speaker. A graduate of UWA, his honour was professional assistant to Kevin Parker, AOQC, Solicitor General of Western Australia, from 1993 to 1994, and following the latter's elevation as his associate. After serving for several years as a legal officer and ultimately assistant to Crown Counsel at then Crown Law, his honour joined the independent bar in Francis Burt Chambers in 2001. During his time in Chambers, his honour served for some 4 years as a member of the Chambers Board, including for more than half that time as Company Secretary. His honour was appointed Senior Counsel in 2010 and elected President of the WA Bar Association in 2012, a position which he occupied for some 3 years. His honour became Solicitor General in July 2016 and served in that role until his appointment as WA's 14th Chief Justice in August 2018. The title of his honours address tonight is The Rule of Law in a Social Media Age. At least one online commentator has summed up the impact of social media on society with the simple word, Profound, that may well be an understatement. Ubiquitous, pervasive, enveloping, and perhaps overwhelming are some other expressions which readily spring to mind. Indeed, since the first recognisable and now largely forgotten social media site was created some 25 years ago, known as 6 Degrees, there has been an incremental explosion of social media platforms. Social media age is one of memes, influencers, hashtags and blogs, and tonight we are grateful to the Chief Justice for casting a spotlight on it in his address. His Honour's address will conclude by 6:30 p.m, and I invite you all to join us for drinks and canapés afterwards. Chief Justice.
Thank you to Elaine Musicant, SC, and to the Board of Francis Burt Chambers for your kind invitation to present the 2022 Sir Francis Burt Oration. I'm particularly honoured to have been invited to deliver the oration in the year that marks 60 years since FTP Burt QC established the chambers that now bear his name, and which is committed to upholding Sir Francis's commitment to excellence, integrity and independence. We are also honoured by the presence of members of Sir Francis's family, Mr. Sally O'Connor and her husband Peter. Thank you for being with us this evening. Can I too commence my remarks by acknowledging the traditional custodians of the land on which we gather tonight, the Whadjuk people of the Noongar Nation. I pay my respects to all Noongar elders past and present and to their continued observance of the laws and customs that maintain their traditional connection to the land and waters of this region. Acknowledging the traditional custodians of this land helps to introduce an important theme in my remarks this evening. That is because the notion of a tradition is an important part of the topic of my remarks, the rule of law in the social media age. The rule of law, to which I'll return in a moment, forms an essential part of our own legal tradition. It is, as the High Court has said, a shorthand description of a complex concept central to an appreciation of the form of government that adheres to the text and structure of the Commonwealth Constitution. Regardless of the extent to which that concept limits or contracts legislative or executive power under our Constitution, the rule of law is nevertheless an enduring concept that underpins the entirety of our legal tradition. As Sir Owen Dixon said in the Communist Party case, the rule of law is one of the traditional conceptions assumed by the Constitution and upon which it is based. For this reason, striving to better understand what we mean by traditional in the context of an acknowledgement of country, which itself depends upon the acknowledgement of the laws and customs of traditional custodians, may help to situate the importance of a sense of tradition in our own understanding of the rule of law. A deeper appreciation of what tradition means to the first peoples of this continent can help us to better understand and appreciate what is at stake in traditional concepts such as the rule of law and how those concepts interact with the social environment in which they operate. In this regard, the inherited legal structures under which we, as lawyers and judges, discharge our professional duties has much to learn from the respect for and adherence to the structures of other traditional legal systems. I was reminded of this earlier this year when I had cause to meet and to discuss a matter of mutual concern with a Pitjantjatjara elder of the Central Desert region. In explaining the significance of a particular matter of traditional law to me, the elder said words to the effect that, as a senior lawman, he had a particular responsibility to protect the integrity of this particular law, and he emphasised the immutable quality of that responsibility with the words, quote, "that can never change." He then added that I, of all people, should understand that responsibility, because as he put it, you are a senior lawman for your law. It was a striking reminder of the fact that respect for tradition, for the rule of law, is something that can and should operate across diverse cultures, and that each of our traditions and our respect for them is enhanced rather than diminished by coming into contact with one another. While I'm on this point, let me allow me to dwell a little longer on the meaning of traditional law and custom in this context, this time drawing upon the High Court's native title jurisprudence. In members of the Yorta Yorta Aboriginal community in Victoria, Chief Justice Gleeson and Justices Gummo and Hayne observed that the word traditional is apt to refer to a means of transmission of law or custom. Their Honours continued, quote, "A traditional law or custom is one which has been passed from generation to generation of a society, usually by word of mouth and common practice." Their Honours went on to emphasise the inextricable link between a society and its laws and customs, and that the vitality of that society is what gives the laws and customs their vitality. The social nature of traditional laws and customs was thus emphasised. For example, their Honours said, and I quote again, "Laws and customs do not exist in a vacuum. They are, in Professor Julius Stone's words, socially derivative and non-autonomous. As Professor Honore has pointed out, it is axiomatic that all laws are laws of a society or group. Or as was said earlier in Peyton's jurisprudence, law is but a result of all the forces that go up to make up society. Law and custom arise out of and in important respects go to define a particular society. In this context, their Honours said society is to be understood as a body of persons united in and by the acknowledgement and observance of a body of law and custom. As the sources cited in this passage make clear, their Honours were not here making an observation unique to Aboriginal societies, their laws and customs. The point is rather a general one about laws and societies, and about the socially derivative nature of all laws and legal traditions. The social nature of laws and the dependence on the social world for their continued vitality points to the other half of my topic this evening, the age of social media. To be clear, I do not propose in these remarks to focus on social media itself and how it interacts with the courts, the legal system, or particular laws. I don't propose any analysis of the interaction, for example, between social media and the law of defamation, or freedom of speech generally, or with the law of contempt. These are, of course, matters of great importance and great consequence. Much can and is being said about them by others. They are not, however, the focus of my remarks. My focus, rather, is on the age of social media, what might be described as the social and philosophical underpinnings of our current age. I refer to it as the age of social media because I suggest social media has become the most conspicuous manifestation of, and in many respects, a synonym for those social and philosophical underpinnings. Before identifying what I think are some of the salient features of our age, the age of social media, I should start by identifying what exactly I mean by the rule of law in the context of these remarks. This is always necessary when we embark on any discussion of the rule of law, because it is a protean concept, the content of which is highly contested and is expressed in many forms. Lord Bingham of Cornhill said in the preface to his magisterial work, The Rule of Law, written after he delivered the Sir David Williams lecture in 2006, the rule of law was chosen as his subject because, quote, "the expression was constantly on people's lips. I was not quite sure what it meant. And I was not sure that all those who used the expression knew what they meant either, or meant the same thing. Lord Bingham's The Rule of Law traces the history of the concept of the rule of law in Western thought. That history includes modern expositors of the concept such as A.B. Dicey and Joseph Raz, as well as their classical predecessors, including Aristotle. Indeed, while he did not use the particular phrase, the rule of law, to my mind, Aristotle captured well the essential meaning of the core concept when he said, quote, "It is better for the law to rule than any one of the citizens." I like this rendering because it calls to mind, with some embarrassment, my own misunderstanding of the meaning of the rule of law when I first heard the expression many years ago. While I can no longer remember when it was or for how long I laboured under the misconception, when I first heard the phrase the rule of law, what immediately came to my mind was a rule, in the sense of a principle, maxim or regulation governing individual conduct, as in a rule of thumb, the rules of the game. You must obey the rules. The rule of law, therefore, conjured in my mind the notion that there was a rule somewhere. A rule called the rule of law, which was apparently important, but of which I had no conception. Indeed, the rule of law, as I understood the phrase, seemed to be something of a tautology. It sounded to me, at least, something like the rule of rules or the law of laws. It was only much later, I have to confess, that I realised that the phrase did not use the word rule in this sense at all. Rather, the rule of law used rule in the sense of government or control, as in the ruling class, the rule of Queen Elizabeth II, or long may she rule. With this clarification, I finally understood the rule of law to be a statement about that which rules us, namely, that people do not rule us, the law does. It is the same idea captured by John Adams' phrase, enshrined in Article 30 of the Massachusetts Constitution, that the government of that Commonwealth would be to the end, quote, a government of laws and not of men. It's perhaps worth reminding ourselves that that famous phrase was used by Justice Blackburn in the Gove Peninsula land rights case 2 decades before the decision in Mabo and Queensland No. 2 to describe the laws and customs of the Yolngu people. Justice Blackburn said this: "The evidence shows a subtle and elaborate system highly adapted to the country in which the people led their lives, which provided a stable order of society and was remarkably free from the vagaries of personal whim or influence. If ever a system could be called a government of laws and not of men, it is that shown in the evidence before me." We may safely conclude, therefore, that the rule of law in this sense has been part of the legal traditions on this continent for tens of thousands of years. Lord Bingham, in The Rule of Law, offered his own non-exhaustive definition of the rule of law. He said, "The core of the existing principle is, I suggest, that all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly made, taking effect generally in the future and publicly administered in the courts." This definition is, of course, not comprehensive, and Lord Bingham spent the balance of the rule of law exploring different aspects of it in more detail. In doing so, he distinguished between what have been referred to as thick and thin conceptions of the rule of law. Thin conceptions of the rule of law, such as those attributed, fairly or not, to A.B. Dicey, tend not to include reference to the substantive content of laws, but rather their accessibility, their clarity, consistency, and prospectivity. Thick conceptions of the rule of law, by contrast, include as a central component of the rule of law the protection of fundamental human rights and freedoms. As Lord Bingham, who stood firmly on the side of a thick conception, said, "A state which savagely represses or persecutes sections of its people cannot, in my view, be regarded as observing the rule of law, even if the transport of the persecuted minority to the concentration camp or the compulsory exposure of female children on the mountainside is the subject of detailed laws duly enacted and scrupulously observed." Again, such a conception of the rule of law has much to recommend it, even if, as Bingham acknowledged, this is a difficult area since there is no universal consensus on the rights and freedoms which are fundamental, even among civilised nations. For present purposes, however, I want to focus on an aspect of thin notions of the rule of law. For without observance of even thin conceptions of the rule of law, a society has little hope of the protection of fundamental rights and freedoms commonly included within its thick variants. Indeed, I want to focus on an aspect of the rule of law so obvious that it is sometimes overlooked, namely that laws are objective standards. In a society that observes the rule of law, the law exists logically prior to and conceptually outside the mind of a single individual. As we have seen, laws are, of course, socially derivative and non-autonomous, but once made, they are objective in character. This is, of course, the whole point. Under the rule of law, we are ruled by objective laws and not by the whims or preferences of persons. But of course, those objective laws must nevertheless be executed and applied by human beings. The law is, after all, a human institution. Nevertheless, the rule of law presupposes that laws will be interpreted and applied objectively. It presupposes that the objective interpretation and application of the law is something of which humans are capable. The particular human beings that the rule of law presupposes are capable of doing this, of course, are the independent judiciary and, more broadly, the legal profession. To adapt Justice Blackburn's description of the legal system of the Yolngu people, the rule of law presupposes that there can exist people who are able to apply the law free from the vagaries of personal whim or influence. That is why the independence and impartiality of the judiciary is so essential to any conception of the rule of law. For without a human institution that can objectively administer the law, there is no means by which the law can rule. This, of course, may all sound obvious. In some respects, I hope it does. If judges and lawyers lose sight of the objective nature of their professional duties, the rule of law will soon collapse. I'll return to this idea later. But for now, I want to turn to the age of social media and what much of what we see on social media reveals about our public culture. Because as much as the reality of the objective application of law is essential to the maintenance of the rule of law, so too is the social perception and acceptance of that reality. And that is where social media comes in, because any passing reference to social media reveals that it is marked, above all, by a radical subjectivity. To identify what I mean by this, I want to draw on the work of two North American philosophers, both now in their 90s, but whose work, particularly in the 1980s, was in many ways prophetic in describing the age in which we now live and work. In his 1981 book on moral philosophy, After Virtue, Scottish-American moral philosopher Alistair MacIntyre sought to explore the particular problem of moral or ethical disagreement in our age. Early on in the book, MacIntyre said this: "The most striking feature of contemporary moral utterance is that so much of it is used to express disagreements. And the most striking feature of the debates in which these disagreements are expressed is their interminable character. I do not mean by this just that such debates go on and on and on, although they do, but also that they apparently can find no terminus. McIntyre wrote that in 1981. If it was true 41 years ago, how much more so has public discourse in relation to political and ethical issues become a polarised battle for ascendancy in which there can be no common ground or satisfactory resolution, merely success or defeat. McIntyre identifies much of the cause of our predicament as coming from the philosophical theory known as emotivism. As he describes it, emotivism is the doctrine that all evaluative judgments, and more specifically, all moral judgments, are nothing but expressions of preference, expressions of attitude or feeling, insofar as they are moral or evaluative in character. Moral judgments, being expressions of attitude or feeling, are neither true nor false, and agreement in moral judgment is not to be secured by any rational method, for there are none. It is to be secured, if at all, by producing certain non-rational effects on the emotions or attitudes of those who disagree with one. We use moral judgments not only to express our own feelings and attitudes, but also precisely to produce such effects in others. Just pause it there for a moment. If you replace the word moral in this passage with the word legal, the kind of evaluative judgment with which the rule of law is concerned, you will get an idea of where I'm heading. McIntyre, to be clear, disagrees with emotivism as a moral theory, and much of After Virtue is an exercise in trying to find a way back to rational moral discourse. I happen to agree with McIntyre in this regard, but that is not important for present purposes. What is important for present purposes, I want to suggest, is the fact that emotivism is, in many respects, the default position of our public discourse. Regardless of our avowed theoretical standpoint, as McIntyre puts it, to a large degree people now think, talk and act as if emotivism were true. Emotivism has become embodied in our culture. I think that this is true. It's certainly true of what one sees on social media and public discourse more generally. Evaluative judgments are almost always expressed in highly personalised terms and proceeding from one's own inner experience. Witness the rise in phrases such as my truth and your truth. Indeed, we often see in our public discourse that the application of an external standard, any external standard, is regarded as an affront to and an attack on one's personal integrity or well-being. A related phenomenon, described by Canadian social and political philosopher Charles Taylor, is expressive individualism. The culture by which, quote, people are encouraged to find their own way, discover their own fulfillment, do their own thing. Expressive individualism is often associated, perhaps unfairly, with youth and youth culture, and the notion that young people, millennials, are particularly and perhaps uniquely self-absorbed. Witness the phenomenon of the selfie. I think that this criticism, however, is unfair. Expressive individualism is not a characteristic of the young. It is a characteristic of us all. It has been a tacit philosophy of the Western world since at least the rise of post-World War II consumerism. It is simply accelerated with the pace of technology. Nevertheless, to a greater or a lesser degree, it is the culture making a criticism. I'm simply identifying the social reality in which we all live and work. The combination of emotivism and expressive individualism produces in us all a potent attachment to our own evaluative judgments, be they political, ethical, or aesthetic. This in turn affects all of our social institutions, religious, governmental, educational, and so on. Those institutions are no longer traditions into which we are initiated and formed. They now exist in service of our self-actualisation. As Israeli-American conservative political scientist Yuval Levin put it, quote, "We have moved, roughly speaking, from thinking of institutions as moulds that shape people's character and habits, towards seeing them as platforms that allow people to be themselves and to display themselves before a wider world." I think this is in many cases true. Let me give perhaps a small example from one such institution, the university. My daughter, who is studying politics, philosophy and economics at a local university, my alma mater as it turns out, was earlier this year enrolled in the core unit in logic. The name of the unit was not something such as Foundations of Logic 101 or Principles of Logic 101. The official name of the unit, as it appears in the course guide, is Logic, How to Defeat Your Foes with Reasoning. Gone, it seems, is any pretense that through the exercise of reason and logic a student might arrive at some new or previously undiscovered truth. It is taken as axiomatic that a student will have a preformed attitude or mental preference, and that what a university course can offer is the means by which, in defeating one's foes, the preformed attitude or mental preference can prevail. Anyone with a passing knowledge of social media will be familiar with this phenomenon. Interlocutors on social media do not persuade, debate, or even argue with one another. They destroy, demolish, or defeat one another. The absence of true rational exchange, I want to suggest, however, is not the problem here. It is rather the symptom. It is a symptom of tacit emotivism and expressive individualism. The notion that all evaluative judgments are merely expressions of preference, feeling or attitude, and that the purpose of politics, education and media is merely to provide a platform for their expression, and that all evaluative judgments are radically and essentially subjective. And it is this radical subjectivity, I want to suggest, that gives rise to a real threat to the rule of law. Because a culture which tacitly assumes that all evaluative judgments are expressions of subjective personal preference or attitude will have a great deal of difficulty accepting or even appreciating that some evaluative judgments are in fact the application of objective laws and not the whims or preferences of individual persons. And given that those judgments and decisions are decisions with outcomes that affect people's lives, such a culture will naturally understand those outcomes to be the product of those personal preferences. This disconnect between the objectivity inherent in the notion of the rule of law on the one hand and emotivism embedded in our culture on the other, I suggest manifests itself in a number of ways. It is, for example, commonplace in social media, and indeed in traditional media, to see the outcome of legal proceedings described in terms that suggest that the outcome is, in fact, the expression of the individual judge's preferences or attitudes. Not long ago, for example, the outcome of an application before the Supreme Court of Western Australia, which saw the respondent released on a supervision order under the High Risk Serious Offenders Act, was reported under a headline that read, "Sympathy for the Devils." The headline could only be understood as reporting that the judge concerned had made the relevant decision out of sympathy, that is, a personal preference, rather than by conscientious application of an objective law. Worse still, it suggested that the judge was motivated by sympathy for devils, implying that the judge was actively promoting a personal preference for evil. But this, I think, misses the deeper point. To identify the outcome in a particular case with the personal preferences of the judge concerned may not simply be, if at all, a matter of imputing bad faith to the particular judge. Rather, it may reflect a more fundamental problem, namely that everyone assumes it could be no other way. Of course the judge decided the case in accordance with her preferences, attitudes and feelings. After all, that is true of all evaluative decisions. Why should a judge be any different? This near exclusive focus on outcomes and their tacit association with the personal or political preference of judges is often a widespread view of judicial decisions. It was on full display earlier this year following the decision of the Supreme Court of the United States in Dobbs and Jackson Women's Health Organisation, which overruled the 1973 decision in Roe versus Wade. I raise that decision tentatively because any Australian judge should be cautious in remarking on the legal system of another country. I have concluded, however, that it is appropriate to do so because it's illustrative of the kind of social and legal issues I'm trying to address. It's also important because those issues are not confined to our own country. Indeed, I think it's fair to say that the United States is a good deal further down the road than we are in this regard. To look to the United States may therefore help us to see more clearly the dangers that may lie ahead and in relation to which we must be on guard. And of course, I could hardly ignore the decision. When it was delivered on the 24th of June this year, the internet and social media in particular exploded. Depending upon which corner of the internet one looked in, the decision was applauded, or as was more commonly the case, derided in the strongest possible terms. Indeed, a week after the Supreme Court delivered the decision in Dobbs, a large number of men and women protesting the decision marched down St George's Terrace onto Barrack Street and past the windows of the David Malcolm Justice Centre. The protest was aimed squarely at the outcome of the decision and the judges who made it. In that regard, I think we can be fairly confident that our fellow West Australians were not marching in protest over a decision of the United States Supreme Court because they disagreed with the court's analysis of the due process clause of the 14th Amendment to the United States Constitution, or took issue with the direction of the court's jurisprudence in relation to substantive due process. They were rather protesting the outcome of the decision on access to abortion in the United States and its potential impact elsewhere, and at least implicitly protesting that the decision was the result of the subjective personal or political preferences of the individual judges concerned. Whether the perception in that regard reflected the reality is a more troubling issue for the rule of law, to which I'll return. What was notable about the reaction to the decision in Dobbs was that at both ends of an extremely polarised political and social debate, both sides explicitly appealed to the rule of law as supporting their position. Those who praised the decision hailed it as a victory for the rule of law. Those who denounced the decision lamented that it had abandoned the rule of law. And this was not confined to advocates, critics or political commentators either. All of the justices of the US Supreme Court appealed to the rule of law as supporting their conclusion in Dobbs. The justices in the majority, for example, said that their decision was, quote, what the Constitution and the rule of law demand. In almost identical language, the dissenting justices said precisely the opposite, stating that their conclusion was, quote, what the rule of law requires. The dissenting judges earlier said that the opinion of the court had substituted, quote, rule by judges for the rule of law. In this way, the rule of law itself becomes a rhetorical device in an interminable debate. As Professor Judith Sklar acertedly suggested, quote, the rule of law might well have become just another one of those self-congratulatory rhetorical devices that grace the public utterances of Anglo-American politicians. No intellectual effort need therefore be wasted on this bit of ruling class chatter. Even more tellingly, Lord Bingham recounted commentary by Professor Jeremy Waldron in relation to another US Supreme Court decision, Bush versus Gore, that, quote, recognised a widespread impression that utterance of those magic words, the rule of law, meant little more than hooray for our side. This particular quote is telling because it echoes precisely how Alistair McIntyre described emotivist theories in After Virtue, namely that, quote, to say this is good was to utter a sentence meaning hooray for this. The widespread impression that Professor Waldron recognised surrounding Bush and Gore, and that almost everyone had of Dobbs on both sides of the political and social divide, was a perception of emotivism. A perception that the evaluative judgments of all of those involved were nothing but expressions of personal or political preference. Even more troubling in the case of Dobbs, and indeed the 50 years of polarised political battles played out in relation to judicial appointments in the United States over that time, is the prospect that the perception actually reflected the reality. As Justice Stephen Gaither recently remarked in an address to the Australian Judicial Officers Association in relation to the reactions to Dobbs, quote, were those reactions attacks on judicial independence, or were they manifestations of an erosion of judicial legitimacy resulting from a realistic perception that a partisan process of judicial appointment had led to a partisan judiciary? Although it pains me to say it, he said, I have difficulty escaping the conclusion that it was the latter. And of course, the reality of a partisan judiciary is an even more existential threat to the rule of law than the perception of one. Nevertheless, I hope it is apparent from what I've already said that emotivism in our culture generally, the widespread assumption or perception of subjectivity in relation to what is or should be an objective determination according to law, itself threatens to undermine the rule of law at its very roots. One of the ways in which it does this is that it necessarily flattens out any hierarchy of authority in relation to evaluative judgments. It is taken as given in any discourse characterised by emotivism and expressive individualism that all evaluative judgments are of equal value and that there is no criteria by which one might prevail over another. You have your view and I have mine. Who are you to say that you were right and I am wrong? Debate becomes a contest of wills rather than a contest of reason. We see this in the phenomenon of the sovereign citizen movement, in which our fellow citizens deny the entire legitimacy of our legal system based on a mixture of social and political philosophy and pseudo-law, which commonly draws on historical legal authorities such as the Magna Carta. All of it is, of course, wholly misguided. Nevertheless, it is striking how sincerely and ardently such beliefs seem to be and how impervious to reason they are. and how the sovereign citizen takes it as axiomatic that his or her judgment sits on an equal footing with that of the court, and as a result of their sovereign status should prevail. Significantly, and it's something of a paradox, the sovereign citizen almost always has a fervent belief in the importance of the rule of law as they see it. Indeed, the sovereign citizen is deeply committed to the rule of law. It is simply that the law for them happens to be the idiosyncratic subjective opinions that they hold or have absorbed from social media. But again, it is a mistake to think of sovereign citizens as simply bizarre outliers wholly unconnected to our legal system as a whole. They are, I want to suggest, simply the extreme end of a continuum that tacitly regards any decision of the court applying the law as merely one opinion among many. The same tendency can be seen in litigation involving large commercial actors, where the courts are regarded as simply one of a number of tools in the party's strategic and commercial armoury, and by no means the most important one. It can be seen where court orders are routinely treated as aspirational guidelines rather than binding obligations. It is most concerning, however, when it is seen in the actions or attitude of the executive government. The courts, after all, are unable to enforce their own orders. They are in large part dependent upon officers of the executive government to execute them and enforce them. And when those orders are orders directed to the executive government, they are dependent upon officers of the executive government to implement them and obey them. It does not take much imagination to see that if executive governments take the view that decisions of courts are simply one point of view among many, or that the executive may take the view that a decision is wrong in law and need not be followed, the rule of law will not long survive. Again, this might not be the result of willful defiance, but because of a belief, sincerely held, that the true legal position is otherwise than is declared by the court. In AFX 17 and the Minister for Home Affairs, for example, the Federal Court, Justice Flick, made orders requiring the Minister to make a decision regarding the applicant's application for a protection visa within a reasonable time. While those orders were outstanding, a representative of the Minister wrote to the applicant's representative in the following terms. Quote, as the Minister has now appealed the judgment of Justice Flick, no decision will be made on your client's visa application pending the outcome of the appeal. The Minister's position is that Section 501A is an available power in relation to your client's visa application, and that Justice Flick was in error in finding that the delay in making such a decision was unreasonable, and that Section 105(1)A is not an available power in the circumstances of this matter. As a consequence of this and other actions by the executive in that case, Justice Flick made a succession of orders requiring action by specific times. His Honour added that it was prudent to observe that in the event of non-compliance with the final order made, contempt proceedings would be instituted. Such an admonition of the executive government was seen as necessary is, to say the least, striking. Indeed, there are many striking things about AFX 17. However, one thing that is particularly noteworthy for present purposes is the unabashed and apparently guileless nature of the email from the Minister's representative. The author gives no hint that there is anything incorrect, unorthodox or unusual about the view that's been expressed, namely that the Minister regards the court's decision as being in error and therefore it will not be complied with. The author is quite open in regarding the decision of the court as simply one opinion among many, and as a result, one that need not be obeyed. While no doubt sincere, and indeed because it was sincere, such an approach by the executive is simply a manifestation of the phenomenon I've been describing. The tacit view that the decision of the court applying the law is merely one opinion among many. And it is no less wrong and and no less inconsistent with the rule of law than the vagaries of the sovereign citizen. We should therefore not think of these as isolated instances. They are all, I suggest, the common outworking of a social environment in which all evaluative judgments are prima facie regarded as subjective and in which there is no hierarchy of value in relation to such judgments. All of which is to emphasise that all the branches of government, the legislature, the executive and the judiciary, have a particular responsibility to maintain and uphold the objectivity upon which the rule of law depends. All branches of government are responsible for arresting the growth of emotivism in our public institutions. And we each have a particular responsibility in the face of a social media culture that wants to suggest otherwise, to create a civic culture that holds fast to the notion that the objective laws that rule us can be and are interpreted and applied objectively. The judiciary, in which I include as an essential component the legal profession, has a particular responsibility, of course, to ensure that the perception of objectivity remains a reality, as the cautionary tale of the United States over the past 50 years demonstrates. As Justice Gabler has said, essential to the maintenance of the rule of law is not merely judicial independence, but judicial legitimacy. And judicial legitimacy, the public's confidence in the capacity of the legal system to produce outcomes according to the law without fear or favour, requires us to redouble our commitment to judicial competence and judicial impartiality. We ourselves must resist the temptation in our work to fall into the twin traps of emotivism and expressive individualism. To do that, I return to where I started, the respect for and adherence to our own legal traditions, and in particular the traditions of independence, impartiality and objectivity that so characterise the life and work of Sir Francis Burt. And to recognise that decisions we make in our professional lives must always be measured against and assessed in light of the legal tradition of which we form a part. A tradition to which we all contribute in our own way, no doubt, and on which occasion we must collectively correct. It is, after all, a living tradition, what McIntyre described as a, quote, historically extended, socially embodied argument, and an argument precisely in part about the goods which constitute the tradition. So the legal tradition of which we form a part must, of course, maintain its vitality and its capacity to self-correct if it is to continue to serve the community for which it owes its existence. But for all of that, it is a tradition that is greater than us. And as that senior pitch in Jarrah lawman made clear to me, it is a tradition the integrity of which we have a particular and immutable responsibility to protect. And I can think of no better exemplar of the discharge of that responsibility than Sir Francis Burt, whose memory we honour this evening. Thank you for your attention.
This is the fourth year in which the Sir Francis Burt Oration has been given, but I believe it is the first time that we have been addressed by a current member of the judiciary. The Chief Justice has taken us all on an engaging and erudite journey through the age of social media and its intersection with the rule of law. He has emphasised the importance of maintaining the objectivity and the objective nature of the rule of law, despite all the challenges that are presented to us in this age. We are very grateful to His Honour for having done so. His Honour's address raises important questions concerning social media and the conspicuous manifestation that underpins our current age, both socially and philosophically. His Honour has given examples of expressive individualism, of emotivism, and radical subjectivity, and how those concepts present potential threats to the rule of law itself. Within a single generation, social media has changed the way in which so much of society receives its information. It has changed both the nature and the sheer volume of information available to us. But perhaps most significantly of all, it has also changed how many millions of us interact with our fellow human beings on a daily basis. Ultimately, history alone will determine whether these now crucial platforms for human connection, and therefore these powerful vehicles for conveying expressive individualism, emotivism, and radical subjectivity, would have been for the better or for the worse. But whatever the final judgment of history may be, I'm pleased to say that, consistent with recent practice, tonight's address will hopefully also soon be available for viewing on one of those platforms, with comments disabled, of course. On behalf of everyone here tonight in Francis Burt Chambers, may I ask you to join me in thanking the Chief Justice for his interesting and erudite address. Before we break for refreshments, may I also express my particular thanks to Pauline McKay and the staff of Francis Burt Chambers for the extraordinary amount of work that they've put in to making this event the success that hopefully it will be. I ask you to thank them also in the usual way. Thank you. Please join us all for drinks.